But here's some of our questions that we got, emails, and let's get to some of these. So, a 91-year-old mom who's currently in rehab nursing home facility has Medicare. Rehab will expire in 5 days. Okay, because you know that with Medicare doesn't cover long-term care. Medicare covers rehab, and the fact that they've got 5 more days, that's about right. 7-day care plan, 7 days at a time is typically how they do the rehab. Um, but here's a little curiosity here. Family planning on applying for Medicaid, placing a nursing home part of the facility. Okay, that's all good. That makes total sense so far. However, she's not doing well, will unfortunately pass before Medicaid eligible. Really? What does that mean? Does that mean she's in rehab? See, because if she's that close to death's door, then most places aren't gonna she's not gonna qualify for the rehab. Now she should because of the definition for what Medicare rehab is and skilled care. She should qualify, but most of the time they say, "Oh, you're not getting better." Boom, 24-hour notice, you're off the rehab. But if the facility, and the facility can do this, if the facility, informally, if the facility says, we're going to keep her on the rehab for the next 5 days, but she's going to make it for 3, then okay, I wouldn't count on that. Too many people, I've seen too many people who, oh, you got 2 weeks to go, and 3 years later, we even have, we even have a client who complained about it. It's like, I had brain cancer and I was supposed to die in 2 weeks, and you did this estate plan. Terrible, because I was going to die in 2 weeks. That was 6 years ago. They survived 6 years. 6 years later, they're complaining about the estate plan we did was inappropriate for someone who's going to live for 2 weeks. And it was like, but you've made it 6 years. What? Anyway, there you go. That happens. So you can't count on people dying. Okay, you can't count on people living. You can't count on them dying on any kind of schedule. But it sounds like they're doing the good things. It's very good. But here's the question that really needs to be answered. If we sign forms, are we legally responsible for the nursing home bill? And the answer is generally not. Now, people get very nervous sometimes they when they sign the forms, and they sign off as the financially responsible party. And when you sign off as financially responsible party, you may think, now understand that they cannot, absolutely cannot require a personal guarantee from a family member or anyone other than the patient. They cannot require a guarantee as a condition of admission. Okay, federal law is very clear on that. They cannot require it. Sometimes, though, and it used to be pretty common, it'll be in the paperwork. So you want to go through the paperwork, make sure you're not signing a personal guarantee. All right, but just because you're acting for someone, our first caller this week, if I'm a guardian, am I responsible for the bills? Am I responsible? No, you're not. No, you're not. But as financially responsible party, you are responsible to use their money for their benefit. Okay, that's one of the things. You're not going to give it away. You're not going to go to the casino or something like that on it. So that's a key. Um, right? So just be sure you're not signing up. The only way they can tag you with liability is if you agree to it. So make sure you're not agreeing to it, and it's got to be pretty clear. But if you're signing a bunch of documents that say financially responsible party, you're still okay, because what that means is not that you're personally guaranteeing it. It just means that you agree to use that person's money for that person's care. Okay. So another one. Father's sister said she was going to leave me something in her will. How do I find out about it? She was in Kansas, and I'm a widow with mental disabilities. Can I still get whatever she left? Well, the answer is yeah, if she actually left you anything, if she had anything to leave. But I'll tell you what, there is nothing more common, very, very common, for people to say they're going to leave you something and then they don't.
This
Okay.
is the David Carey.
And well, thank you for that. That's a very common thing that people will say, "Oh, I'm going to, you're going to get the Lamborghini," and guess what? There is no Lamborghini. It never was. Or I'm going to do this or that. Uh, those are very, very very, very common kinds of promises, and then enforcing them later on. Well, if the person died and didn't have anything, which is the usual case. Okay, NBC did a report. It's a month ago now, I think, but it's very. I mean, you can find this anywhere. This is not news that the $50 trillion that the baby boomers have, right, is not going to go to their kids. The $50 trillion that's going to transfer hands over the next 10 or 15 years is not staying in the family. It's going to the healthcare system. That's where the money's going. Okay. Unless you do something about it. So Auntie may have really had every intention of easing your life by leaving you some money in the will, but it's extremely unlikely that there's going to be any money left because it went for Auntie's health care. That's the typical. Now, how can you find it? We'll find out where she died. She died somewhere in Kansas. Okay. Well, which county did she die in? And then you go to the probate court in that county or the county of residence. We actually had a case on that, whether or not they were physically present in one county, but they had lived their whole life in the other one, and they were just there for the long-term care. And it was like, well, which, and they were challenging us. Oh, you're in the wrong county. It's like, no, resident means where you usually are from. Anyway, that's a whole nother thing. So go find out, was a will filed? If there was no will filed, if there was no estate open, you're not getting anything. Pretty much simple as that. But don't get your hopes up, because the chances are there's nothing to get because it went to Auntie's health care. All right. I think I said that 3 times now. I wanted to file a document stating I'm my adult brother's primary caregiver, ? My adult brother lives with me and has been my dependent for 5 years due to traumatic brain injury, but he is functional but disabled. I need a legal document from my job to seek a benefit. Okay. Well, why not go to... It says he's functional but disabled. So let's assume that he's not mentally competent, traumatic brain injury. Then the way to do that, and it says I need a legal document for my job to seek a benefit. So probably the, Family Medical Leave Act type stuff, because you're taking care of a loved one. Okay, fine. The way to handle that, if they may have forms at your HR department, if they don't, all right, if they don't have those, and you should do this anyway, unless you already have power of attorney and whatnot, which you probably don't. But then go to probate court. Again, this is a little early in the show. We're talking about, well, what about guardian conservator? Yeah, go to probate court, get on board as guardian and conservator. That's the way to do it. If there are no documents that are in place at this point, that'll satisfy your HR department, be the Family Medical Leave Act benefits, which I think is what you're going for.